Article 2176. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provisions of this chapter. Article 2177. Responsibility for fault or negligence under the preceding article is entirely separate and distinct from the civil liability arising from negligence under the Penal Code. But the plaintiff cannot recover damages twice for the same act or omission of the defendant. Article 2178. The provisions of Articles 1172 to 1174 are also applicable to quasi-delict. Article 2179. When the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages. But if his negligence was only contributory, the immediate and proximate cause of the injury being the defendant's lack of due care, the plaintiff may recover damages, but the courts shall mitigate the damages to be awarded. Article 2180. The obligation imposed by Article 2176 is demandable not only for one's own acts or omissions, but also for those of persons for whom one is responsible. The father and, in case of his death or incapacity, the mother are responsible for the damages caused by the minor children who live in their company. Guardians are liable for damages caused by the minors or incapacitated persons who are under their authority and live in their company. The owners and managers of an establishment or enterprise are likewise responsible for damages caused by their employees in the service of the branches in which the latter are employed or on the occasion of their functions. Employers shall be liable for the damages caused by their employees and household helpers acting within the scope of their assigned tasks, even though the former are not engaged in any business or industry. The state is responsible in like manner when it acts through a special agent, but not when the damage has been caused by the official to whom the task done properly pertains, in which case what is provided in Article 2176 shall be applicable. Lastly, teachers or heads of establishments of arts and trades shall be liable for damages caused by their pupils and students or apprentices, so long as they remain in their custody. The responsibility treated of in this article shall cease when the persons herein mentioned prove that they observed all the diligence of a good father of a family to prevent damage. Article 2181. Whoever pays for the damage caused by his dependents or employees may recover from the latter what he has paid or delivered in satisfaction of the claim. Article 2182. If the minor or insane person causing damage has no parents or guardians, the minor or insane person shall be answerable with his own property in an action against him where a guardian ad litem shall be appointed. Article 2183. The possessor of an animal, or whoever may make use of the same, is responsible for the damage which it may cause, although it may escape or be lost. This responsibility shall cease only in case the damage should come from force majeure or from fault of the person who has suffered damage. Article 2184. In motor vehicle mishaps, the owner is solidarily liable with his driver if the former who was in the vehicle could have, by the use of due diligence, prevented a misfortune. It is disputably presumed that a driver was negligent if he had been found guilty of reckless driving or violating traffic regulations at least twice within the next preceding 2 months. If the owner was not in the motor vehicle, the provisions of Article 2180 are applicable. Article 2185. Unless there is proof to the contrary, it is presumed that a person driving a motor vehicle has been negligent if at the time of the mishap he was violating any traffic regulation. Article 2186. Every owner of a motor vehicle shall file with the proper government office a bond executed by a government-controlled corporation or office to answer for damages to third persons. The amount of the bond and other terms shall be fixed by the competent public official. Article 2187. Manufacturers and processors of foodstuffs, drinks, toilet articles, and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used, although no contractual relation exists between them and the consumers. Article 2188. There is prima facie presumption of negligence on the part of the defendant if the death or injury results from his possession of dangerous weapons or substances, such as firearms and poison, except when the possession or use thereof is indispensable in his occupation or business. Article 2189. Provinces, cities, and municipalities shall be liable for damages for the death of or injuries suffered by any person by reason of the defective conditions of roads, streets, bridges, public buildings, and other public works under their control or supervision. Article 2190. The proprietor of a building or structure is responsible for the damages resulting from its total or partial collapse, if it should be due to the lack of necessary repairs. Article 2191. Proprietors shall also be responsible for damages caused 1. By the explosion of machinery which has not been taken care of with due diligence, and the inflammation of explosive substances which have not been kept in a safe and adequate place. 2. By excessive smoke which may be harmful to persons or property. 3. By the falling of trees situated at or near highways or lanes, if not caused by force majeure. 4. By emanations from tubes, canals, sewers, or deposits of infectious matter constructed without precautions suitable to the place. Article 2192. If damage referred to in the two preceding articles should be the result of any defect in the construction mentioned in Article 1723, the third person suffering damages may proceed only against the engineer or architect or contractor in accordance with said article, within the period therein fixed. Article 2193. The head of a family that lives in a building or a part thereof is responsible for damages caused by things thrown or falling from the same. Article 2194. The responsibility of two or more persons who are liable for a quasi-delict is solidary.